So I'm recording this. Okay. Well, I'm excited to welcome my co-host Carol Marak, who is the author of a forthcoming book. I think it's right around the corner, called Solo and Smart. And this term solo aging started popping up in our discussions so often. I was like, well, I got to devote a whole discussion on solo aging. Let me see if there's an expert out there. And if you do a Google search for solo aging, it's basically Carol. You are the pioneer in this field. And one of the reasons we're having this discussion on the legal implications of solo aging is when we had your discussion, I would probably say 60% of the questions from the audience had some tie to legal and financial. And so that's why we're doing this. And I'm so happy that you came back and you're going to co-host this with me, because you're an authentic solo ager. So for the folks that didn't get to meet you in the first discussion, tell us a little bit about yourself. You've got such a great story.
Well, thank you. Thank you, Steve. I really appreciate the invitation to join your group today. And hi, everybody. It's good to see all of you. If you are circling back from the first presentation Steve had invited me to do, and that was about 6 weeks ago, I think. So it's great to be back. I don't see your faces yet, but maybe I will shortly. Yeah, solo aging is a very complicated situation. My background, I was a family caregiver for both my parents. And of course, upon their death, I realized, oh my gosh, that was a lot of work. Growing old is a lot of work, and it's no fun, as revealed by my parents. And so that really woke me up. I call family caregiving my wake-up call. And it really woke me up to what I will face. It woke me up to my future. So thankfully, I'm very grateful that my parents showed me the way. And they really helped show me what I needed to prepare for myself. However, I realized, oh my gosh, they were pretty lucky, because they had 3 loving daughters who took really good care of them. And unfortunately, I don't have a spouse or children to look after me. So that's what really got me on the stick and started thinking about my own aging process. And I'm happy to report that was back in when I'd say about 15 years ago. And I'm very satisfied where I am today. As a matter of fact, I feel like I'm thriving. So and knock on wood, or send out prayers, I should say, that will continue. But I'm very happy how I have prepared. And by the way, Steve, I'm in the process of creating a class that I would love to present to your audience in the near future.
Oh, I love it. And I just dropped your website on into chat. So definitely check out what Carol's doing. And she's got the Solo and Smart book right around the corner. This is great. And one disclaimer for Carol and for the audience is, you guys know I tend to babble on. So Carol, you just break in anytime you need to as my co-host. And
sure.
Folks. So okay. So the topic today, because after this first discussion, there were so many legal and financial questions. In the audience was Mary Motor, who is on the leadership team for Byrd, a law firm. And she was sort of doing her best to sort of field these questions. After that discussion, she said, hey, Steve, would you like an attorney to come on to lead a discussion on legal implications of solo aging? And I was like, absolutely. And for the audience, just so you guys know, we've been doing these online discussions for 20 months. And I will say that there's this thread that seems to follow in these discussions. If there's a topic or something that we talk about, and somebody in the audience kind of calls me up and says, hey, can you elaborate on that more? I go and do it. We met Carol and she's back. Mary connected us with Josh, who we're going to meet here in a moment. And so definitely we want to make these discussions interactive, but we want to respond to you in the audience on the topics that are going to help you. And the fact that these are live and interactive is just so wonderful. Okay. And also, Carol, as you can see, we got over 100 people here. That's why this is a webinar. Unfortunately, we're not going to see their faces today, because if we did, we'd have way too many people on the screen. So without further ado, let's bring on Josh Winger, and let's get to know Josh a little bit better. And actually, Josh, before you, this is like an official thing that I think is really important, is that I'm going to throw a disclaimer up here, Josh, that says this presentation is for general information only, and it's not intended to establish an attorney-client relationship or to give legal advice. I just want everybody to, recognize that, in that we're trying to help you here and sort of, give you ideas and strategies, but don't think that this is denoted as any kind of formal legal advice. But anyways, so Josh, let's tell us a little bit about your background and what led you to your practice as an elder law attorney with Byrd.
Sure. Well, thank you, Steve, and Carol as well for having me on. So let's try to start backwards. So I am an attorney licensed in Maryland and the District of Columbia. Our law firm is located specifically in Bowie, Maryland. I am what is commonly called an elder law attorney. Problem with that term is you ask 100 different people what elder law means, and you'll probably get 100 different answers. But what our firm does is everything from the more traditional things of estate planning, such as powers of attorney and wills, but also get into more complex issues such as supplemental needs trusts, which are also called special needs trusts. Our firm also is involved in long-term care Medicaid planning, which is not the same as Medicare planning. So how I got involved in this is, quite frankly, when I started out as an English major back in undergrad, and I really started looking around for a really practical way to help people. And I gravitated towards the law because there's a lot of one-on-one or direct assistance to people. It's really not abstract. It's really hands-on helping people. And really seemed to be that the law was a fantastic way to help people. And then, quite frankly, whatever I come across attorneys in all fields, and really, frankly, attorneys in all fields that eventually come back to me, because sometimes you have, if you have a personal injury case, what if your client passes away while the case is going on? Or what if your personal injury client has a stroke and needs a power of attorney? So this is really an area of the law that really touches everybody and really touches everybody's life eventually. You might never be in a personal injury case. You might never get divorced. Hopefully you never get divorced. But everybody eventually needs estate planning and elder law. Me personally, I'm married. I've got 4 children at this point. They keep me on my toes as well. The 4 kids, that is, not my wife. Anyway, I'm very happy to be here today and explain some of the information about solo aging.
Great. All right. Well, I know you've got some PowerPoints that you're going to share, and Carol and I will duck behind the curtain here in a moment, but I wanted to share something, and Carol, I'd be interested in your feedback on this, that really came out of our last discussion. And that was, I think originally when the questions would come in from solo agers, and when I stumbled into Carol, I had this vision that, oh yeah, solo agers, it's a person that doesn't have family or may have lost a spouse or what have you, and they're out there solo aging, and there's something powerful about that. It's not a negative, and but in our last discussion, what dawned on me is that we're all potential solo agers, like every single one of us. Like Josh with his 4 kids and his wife is potentially going to be a solo ager one day. We wouldn't want to think about it, but life happens, and so I think when we have this discussion, it's probably the hardest thing is for like a couple who has a good marriage and a good relationship to think about the potential that that they could be solo agers in the future. And I think that has a lot of intersection with the elder law. Carol, any sort of thoughts on that, or some of the conversations that you've been having?
Oh, I absolutely agree that all of us potentially at some point could be a solo ager. My dad was at the age of 85. That was pretty old to have to face aging alone. However, he had, kids to help out, but he was still living alone at 85. Yep. And so there were so many things to think about in addition to legal matters, but it's also social connections. I mean, if you leave or lose, I should say, you lose your spouse, then how are you going to stay connected socially? Or and where are you going to find support if you don't have children that live nearby? So there are so many issues that, as a solo ager, we are forced to think about these things now, early on, basically. However, I think it's a great idea, Steve and Josh, that everyone consider, what are the issues we need to think about.
Yeah. And Peggy Floria in the chat says, you can also be a solo ager if you have kids and siblings and none of them are willing to help you,
Exactly.
So
exactly.
Well, let's, Carol, let's you and I duck behind the curtain, and let's let Josh share his PowerPoint where he's got some talking points and thinking points for us. And I'm going to remind the audience that you can ask questions at any point in time. Just type in your questions there. And then Josh, if you want to share your screen, and if you're having any difficulties, I've got your PowerPoint too. There you go.
All right. Hopefully everybody can see a PowerPoint now.
Yep, got it. Oh, do that display settings thing that we did there before.
Okay. Let's see here. How about now?
Let's.
Still no?
Go to the. I think it's the other one there, the duplicate slide.
Okay.
There, that's it. Oh, no. Well, this is fine. I mean, we're.
No. How about now?
No, now we're not sharing. Here, I can make this easy. I can do it. Here, I got it.
Okay.
Can you see that?
Yeah, I can see that there.
Mm-hmm.
Okay, great.
Actually, no, this is not it. No, that's not it.
That's not it?
No.
Okay.
Let's,
Here.
if you could turn that off, let me try one more time.
Okay, got it. And I always like to remind people that if this was a live event, it could take 5 minutes for Josh to walk up on stage. There, we got it.
All Perfect. Right, fantastic. Thank you, everybody, for, wait.
Huh.
It was there. This all worked 10 minutes ago.
There. Oh, geez. It keeps on going. Okay. Start the journey.
Don't know what is happening.
Well, here's one thing you could do, Josh. Okay.
Hopefully
I
it's
can,
gonna work
I
now.
can see that now. Okay. Yeah.
Okay, hopefully it will keep working.
Okay.
But yeah, so I do agree with what Steve and Carol is saying. So yes, even though I'm married, I very well could be a solo ager at some point in time. Any of us can be. That's a great way of putting what I was touching on earlier, that this area of the law really kind of, in one shape or another, will affect everyone. That's just the reality. So here, the starting of the journey, on this page we have here. So whether you are right now a solo ager or you might be someday, you really have to think about really four categories, main categories to start, is of who you want to help you. Number one is with healthcare decisions. Number two is with financial decisions, and what you want to have happen with your bodily remains. And then the fourth one is honestly the one that, in my experience, a lot of people jump to first, but it's who you want to get what after you pass away. That's, of course, most commonly thought of because the most common question I get is, Josh, help me make a will. But that's, we can talk about that. A will absolutely does not necessarily cover everything that you have, but the first two things, the healthcare decisions and your financial decisions, that's so that somebody can help you while you're alive. And frankly, in my opinion, that's what is certainly much more urgent, that everybody get that squared away. And then once you get that squared away, then you can really start to focus on what happens afterwards. So that really helps people divide up and kind of divide and conquer what they're trying to accomplish. Let me see here. I'm going to try and pull my chat up. No. Anyway, so anyhow, so it's very crucial that you have somebody in your personal life, hopefully, that you can trust with your healthcare decisions. That's the most critical thing. Everything that we're talking about can wait unless it is a healthcare decision. That's the only thing that could ever be an emergency. So you really need somebody in your personal life at the very least who can help you with healthcare decisions if you cannot do that yourself. Friend, family member, next door neighbor, somebody that you trust to help you with your healthcare decisions. The reality is, while you might have a professional, we can talk about that for financial matters, a professional is less likely to be able to be available in an emergency for healthcare decisions. I mean, for example, if somebody names our law firm, we might be in court at the very second that you're having a health emergency, or we might be attending to another client who is having an emergency. So it's a professional is just not necessarily the best person to help you with healthcare decisions. So we really urge everyone to at least first and foremost focus on finding somebody in your personal life who can help you with healthcare decisions. And a better example of somebody who could, if you truly need a professional, a better example than an attorney for healthcare decisions is if you have an aging life care manager. Those are formerly known as the geriatric care manager. Can be one of the better fits if you truly need a professional to help you make healthcare decisions. And healthcare agent, that's the name of the person that you named, or that's the title of the person that you named to help you in your advance directive, which is also called a living will or a healthcare proxy, healthcare power of attorney. Those are all just synonyms. Moving on to the financial aspect, if you need a professional for a financial power of attorney, a bank or a trust company is often the first one that people think of. Unfortunately, for most people, banks or trust companies are just not going to help to be your direct financial power of attorney or a trustee of a trust. That's because most banks now require a $1 million minimum of the assets that they're managing. And frankly, most people just don't have $1 million that they can dedicate just to a bank. So most banks say, I'm sorry, but we will not be your financial power of attorney, or they won't be the trustee of your trust. That's just the unfortunate reality. And that $1 million is actually pretty low now. There's many banks that have higher minimums. So that goes back to, again, if you do not have anybody in your personal life that you trust with your checkbook, so to speak, you might be able to get an attorney. I mean, our firm is definitely the financial power of attorney for far more people than we are the healthcare power of attorney for. Of course, but if you hire, because attorneys don't really have minimums, so to speak. We don't say, do you have $1 million? That's not what attorneys do. That is really what banks do, though. So a financial advisor or a CPA, CPAs are, we see actually quite frequently, as well as somebody to be a financial power of attorney. Trying to also keep an eye on the chat here, see if there's any questions so far.
Let's see. Actually, yeah, Burke just has a question related to what you just talked about. And I'm not sure if Burke is a male or female, but Burke says, what if you have $1 million, but it's in real estate? Do banks require $1 million in liquid assets?
Well, then the bank won't help you. So it's how strict that bank is with their $1 million. I mean, if you have $1 million in rental properties, then the bank and the bank is okay with that, then the bank probably would help you, because there's income coming in on that, which quite frankly, the bank can be paid from. But different banks have different standards. Most banks, though, prefer to have liquid assets because, quite frankly, they can get more money off of those. I'm just being blunt here. If you have $1 million in a brokerage account, they can very aggressively invest that and get money, more money than they can get necessarily if you have $1 million in rental properties, and the bank can do no more than get 5% of rent being paid on $1 million property. Their bank is going to get far less than if they get 5%, for example, on what they invest on a liquid asset.
Okay,
So,
and then Jane has a question. She says the bank requires a minimum for what as a fee, as a deposit. So just to clarify, you were referring to the bank sort of acting on your behalf as a financial power of attorney or a power of attorney, in the event that you had nobody that you wanted to assign that to. And the bank's only going to do that if you have an account with them, correct?
Right. And then, so it's not that you've got $1 million spread out over 5 different places. It's that you have $1 million that particular bank is managing for you, that they are in charge for you as your financial power of attorneys. They want access to your money so that they can make money off it. Virtually every single bank, they're not paid by the hour. They get paid as a percentage of what they're managing for you. And that can be quite costly. And again, banks, they don't really want 5% of a $100,000 account. They want 5% of millions dollars account. So that's just the unfortunate reality. And I'm addressing that kind of, that's one of the first things, because that's a common question that I get for people who are absolutely solo agers. It's not even a possibility for them. They actually are solo agers, and they say, hey, Josh, I'm thinking about going to talk to Bank X about being my financial power of attorney. And that person, I say this with 1,000,000% respect, all they really have in the bank is a few $1,000s. And I just have to break to them, said that's not a solution for you. So because that bank will tell you no. So it goes back to, do you have anybody in your personal life that you can trust? And if you truly don't, then you might be able to hire a firm like us, or a CPA who does not have minimums. But again, even if you hire a law firm like us, there's some money that's going to be charged. That's just the reality. So even aside from the fact that banks do not help most people in this situation because most people don't have enough money. It's banks, attorneys will, but so that the bank, my point is attorneys are the middle ground between you not having anybody in your personal life who can help and the much more expensive of having a bank do it.
Got it.
So I have
Great.
a question. This is Carol.
Mhm.
Josh, I'm curious if you work with certified fiduciaries, like perhaps a CPA. I mean, do you have someone that you refer your clients to, or perhaps even maybe a money manager, a daily money
Mhm.
manager that's certified? And if you do, what type of certifications do you look for and recommend that your clients look for?
Right. So we have a number of CPAs and a number of, we have some daily money managers. There's far fewer daily money managers out there than CPAs. That's really unfortunate because a lot of people could do to use a daily money manager. Daily money manager basically is somebody who helps you write your checks for you because it's hard for you to find the time to write your checks, or it's hard for you to focus in on that or keep track of all the bills that come in the mail. But yeah, there are national certifications for a fiduciary. It tends to be those are CPAs that have that. There are some investment companies that advertise themselves as fiduciary standards. What those tend to be are ones who are not paid commissions, and they have very specific structures that do not involve commissions. Is what I'm trying to say there. But yes, so
Okay.
daily money managers. There's really not any national standard for a daily money manager, though.
Well, okay. Yeah. Perhaps one day there will be.
Mhm.
And in terms of healthcare decisions, financial decisions, anytime we're building a kind of like a team to watch out for us, I do always recommend to my friends or perhaps to members in my group that they build a team of people and always find someone like Steve had mentioned, or maybe you did, Josh, a neighbor or a good friend. But have a team of people who are working together and really looking out for your interests, just like a family would do. Because one or two people, I think it's just too much work. It's too big of a burden if you have one or two friends being your healthcare proxy, and then again as well as your financial proxy, because it's just too much. I think that's my opinion.
Yeah, the American Association for Daily Money Managers, that's been dropped into the chat box for anybody to take a look at there on that specifically. So thank you to see, it was Jennifer who might have done that, Jenny Pearson. So thank you on that. But yeah, so particularly in 2021, it's very easy to start down the isolated road. It's whether you're a solo ager or not, because between Zooms like this, which are very helpful, but or shoot, just even before the pandemic, it's become less and less common for people to know who even lives on their street. So it's, in other words, this here is urging people to fight the urge to become isolated where you are. That does not mean trust anybody who pops their head in your door, so to speak. You do need to be discerning, but you need to try to find people who you can trust. That's just the reality of life. You do need to find people that you can trust. But thank you for that, Carol. Absolutely. And then of course, where I frustrate a lot of people that I meet with is I say, okay, it's a lot of people, it may be difficult just finding one person that they have faith in, that they can trust, but we urge everybody to think of at least one backup. Some people truly cannot think of any backup, and if you can't, that's fine. You know, it's just the way it is. But if you only, for example, if you only name one person in your healthcare power of attorney, or only one person in your financial power of attorney to help you, and that one person, for example, dies before you, or that person gets into a car crash and has a traumatic injury and cannot help you, then that power of attorney is not really helpful anymore for you. That document you made, because you don't have anybody left named in that document to help you when you need help. So, so we urge everyone to at least name one backup to name in their document. The very fortunate people they come to us and they have 5 or so backups that they want to name. That's well and good, but we urge everybody to name at least one. If you really want to have a professional such as our firm named in your power of attorney, either healthcare or financial, we highly recommend that the professional be the backup or the last named successor, because whoever you name as the primary is in your personal life, probably is again more involved with you on a day-to-day basis, and will, again, for example, will know if there's a health emergency faster than the professional will, or can be involved to help you write checks, or to help you find, for example, if a nursing agency needs to come into your home. So the professional is there as a backup you could name as a backup to your primary if there truly is no other reasonable option available. It looks like we might have.
We got questions coming in here. Actually,
yeah, I'm scanning the chat here now.
Yeah, I love this. I love this question that I'm sure you get in your practice a lot. If you have more than one backup successor, how do they make decisions if they disagree?
Well, that's resolved by do not have backups served simultaneously. So for example, your power of attorney would say person A shall do it. If person A cannot do it, then person B. If person B cannot do it, then person C. If person C can't do it, then person D. Our firm almost universally recommends that you never have people served simultaneously. Because if they disagree, if it's a financial situation, you could have a bank or a financial institution throw their hands up and say, go get a judge to decide, because you've named 2 people to serve simultaneously and they can't agree. Or it could be a situation where a doctor will say, or a hospital would say, these people are named simultaneously and they can't agree. Go get a judge to decide. That's not what you want in the first place. So again, you can name as many backups as you want, but name one to serve after the other. That's very critical there.
Great.
Yeah, I just want to mention also, Steve, that another resource that I absolutely highly recommend is the American Bar Association. And they have part of their website, they have for seniors, and I think it deals specifically for elder law questions. And they have downloads, they have PDF files, they actually have created a document of the questions that you walk your proxies and your selected agents. And even before you put a friend or a neighbor or select an elder law attorney or whatever, they give you questions to ask those people. And together you have a conversation saying, this is what I want to happen. If this happens, if I become terminally ill or what have you, or if I'm on a life support system or whatever the situation. And they highly recommend that you get very, very clear before with those individuals you're talking to who are potential proxies, even before you put them down to be one. And I really encourage everyone to go to the American Bar Association and look around. You'll have to dig. And maybe, Steve, I can send you that link.
Yeah, send me that link, because I've never been on their website. But
it's
I'm going to give everybody
resource.
the National Academy of Elder Law Attorneys. That's another one. that we can throw in there.
Yeah, and you can make that, some of those questions, you could actually have your proxy sign it and say, these are my wishes. This is how I want you to follow it. And perhaps, Josh, they could add that to their will, right? Or to their advanced directives. Is that right?
Well, nothing that your proxy signs counts as your will.
But could it be an attachment though?
No. A person can make an amendment to their will, but what's called a codicil. That has to be properly witnessed the same exact way as the will does. A lot of people, I see a lot of unfortunate situations where somebody makes a will, for example, 30 years before they pass away. And then what turns out to be 2 weeks before they pass away, on a scratch sheet of paper, they just try to start making changes and they just try to staple it to their will, and that's no good. No,
okay.
so any amendment you want to make, that has to be properly witnessed the same way that a will does. So that's a real pitfall there. Sometimes, like Maryland has certain law as a law where you can incorporate a document that was in effect before you signed the will, but trying to amend it by just a scratch sheet of paper after you sign the will, that's not going to work. Unfortunately, no. I'm frankly not aware of any state where you can just, as a scratch sheet of paper. There's some situations, such as if you're in the military and you cannot get in front of proper witnesses. There's some holographic exceptions, but those are certainly the exception and not the rule. I see a couple other things in the chat here. Healthcare agent. So similar to what we just talked about, if you want to amend a healthcare power of attorney, Suzanne is asking this, it needs to be properly witnessed, just like the original document is. First off, you should never be writing on an original document after you sign it. So 5 years later, don't make notes on it or scratch somebody's name out. If you're going to amend something, it needs to be a properly witnessed document to keep with that. As far as notarization goes, Maryland does not require notarization for a healthcare power of attorney, but Maryland does for financial powers of attorney. So it depends on exactly what you're trying to accomplish there. And then Pat's got a question about those who have no savings or assets, at least beyond a house. For those who do have a house, but it's mortgaged to 80% or so, or retirement beyond Social Security. There's not a great solution there. I'm not gonna lie. There are some states do have some waiver programs if you have roughly 300% or so of SSI. So that takes you in the neighborhood of about $2,500 per month to get certain benefits. But for most waiver programs, there's long wait lists. Like in Maryland, for example, there's years long wait lists to get some benefits for if you have a low income, meaning no more than 300% of SSI for most waiver programs.
Well, and Josh, on Pat's question there, this speaks to something that you said, as well as what Carol was saying. For Pat, this is where, especially if you're a solo ager, to make an effort to sort of build a network. One of the cost saving solutions that I've seen a lot of solo agers engage in is house sharing. Is that coming together with a group of friends, or like-minded individuals, and living together and supporting each other as solo agers. But it can save money, it can reduce loneliness, and it could potentially be a caregiving role if in the event that somebody needed it.
That's really great,
Absolutely.
Steve.
Yeah.
Just you need to be for example, if two people are going to be sharing a rented home, in that sense, you give specific thought to how is the lease going to be with both people on the lease. So frankly, if one passes away, the other one is still able to stay there. Or if
Mhm.
you're buying a house together, are you both going to be on the title, so to speak? I mean, not so to speak, but are you actually going to be on the title so that if one passes away, the other one is still able to be there? There's what's called joint tenants with right of survivorship, where if two people are on a home, one passes away, the surviving person just continues on as owner. In Maryland's not one of the friendly states for that. If you're just going to co-own a home with a friend, because if you pass away and you or jointly own a house with just a friend, when you inherit that person's half, when the first person passes away, there's about a 10% inheritance tax on the value of the half that you inherit there. So there could be a tax on what you get if you jointly own a house with just a friend. So that's something to bear in mind. But so my point is, don't necessarily move in with somebody without a plan on how that's going to work. If that friend, who may be the only person on the deed or maybe the only person on the lease, passes away, or the point is, go in with eyes wide open there on that. And a related thing on that is probably a good segue to this slide here is going back to Carol. Carol talked about the word fiduciary. Fiduciary is just the formal legal word for saying that whoever you name to help you, whether it's your next door neighbor, your niece, your an attorney, whoever it is you're naming, they've got a responsibility to act for you and not themselves. Yes, that can get very hazy if you're naming a bank and a bank is getting a commission for whatever they do to invest your money. But the point of fiduciary duty is that they're supposed to act for your benefit, whoever you name, and not for theirs. A silly example, but is that they can't take money out of your checking account and go on vacation to Aruba. They have to act for your benefit. And a huge pitfall that I never want to see anybody make is whoever you're naming to help you, do not add them as joint owner onto your accounts or your car or your home. Do not do that. If they're just a person that you want to help you, do not add them as joint owner. Because when you add them as joint owner, then they legally co-own it with you right then. And legally, they have the right to, it's arguable they've got the right to do whatever they want with what's in that account. There's a Maryland case where a man sued his daughter that he had as joint on the account. I'm not going to bore you with all the details, but that got too complicated. Point is, that's what a power of attorney is for. If there's a person that you want to help you, you name them to help you in a power of attorney. Do not add them as joint owner onto what you have. Again, that's what the power of attorney is for. The most common thing that I see is somebody takes their niece or their next door neighbor into a bank and say, I want this person to be able to write checks for my benefit. Happens every day in this country. That's what you're asking, is you want a person to be put on as authorized user or power of attorney, not as joint owner. Do not let the bank give you the form to name the person as joint owner. It should only be authorized user or power of attorney. But now specifically on this slide here, whoever you're naming, you've got to communicate with them. Now, you may not be comfortable giving them a copy of your will or your financial power of attorney while you're still healthy, but you at least need to tell them where they can get the important documents. At a bare minimum, you should give them a copy of your healthcare power of attorney, which is also called advance directive or living will, healthcare proxy. You should give them a copy of that. But at the if you want to just tell them where you're keeping everything else, fine, but they do need to know where they can get your information. Safe deposit box. Burke is asking a question about a safe deposit box. If you name a person to be on your directly in a bank system to access your safe deposit box, then they can go into it immediately. By contrast, if you just name a person in your power of attorney to have access to your safe deposit box, if the power of attorney says it's not in effect until you are declared incompetent, then they would not be able to go into the safe deposit box until you are declared incompetent. But some random bank that if you name the person as directly in the system, in the bank system, then they could go into it immediately. And for those of you who are fortunate enough to live in a state where your will can be filed in advance at the courthouse, that is a far better place to put your last will and testament. In Maryland, each county has their own vault where you can pre-file your will at the courthouse. New York is another state that has that. So if you pre-file your will at the courthouse, then there's no issue with trying to find your will after you pass away, or it getting lost or burned up in a fire. None of that is an issue because it's already at the courthouse. And just because you filed at the courthouse doesn't mean you can't change it the very next day. If you want to, you can change it. So for all of our clients, at least our Maryland clients, we highly recommend they all file it. They all let them file it, let us file it at the courthouse for them. But I have, even during the pandemic, having ones where a person would still put their last will and testament in a safe deposit box, and they did not have even anybody authorized to get into the safe deposit box. So literally the register of wills herself would have to go out to the safe deposit box, take the will back to the court right there, all during the middle of the pandemic. We're seeing that happen.
I tell you, Josh, Burke is winning the award for the best questions today, but I want to make sure that you can get through the slides that you wanted to share with us as we're getting close to the top of the hour. But Burke does ask, I've been told by banks that they will not accept my general power of attorney, but require their own forms. Is this true?
In Maryland, that would not be true, no. In Maryland, in October of 2010, the Maryland General Assembly, the Maryland legislature passed a law that if you use one of the very specific statutory powers of attorney, then banks who do business in Maryland are required to honor it. There are other states out there that do not have such a law. I mean, prior to October of 2010, technically that would have been true, Burke. But if you use a statutory one in Maryland, then banks that do business in Maryland are required to honor it. And I see one more thing from Burke is, yeah, it's not really a question, but he's saying basically beware of annuities. And I would agree about that. Annuities can be good for some people, but they're not good for everybody. And not all annuities annuities are not one size fits all. So if you're going to do an annuity, just like if you're going to think about doing a reverse mortgage, you really have to look at your own specific situation and see what's going on there. We already talked about in this slide, make sure you know where the original of your will is. And then giving a copy of your documents to other people. At the very least, you give a copy of your healthcare power of attorney. This is our information here. So something that we I touched on just briefly, I just want to take the last 60 seconds I have here to go over something that's very important. A will does not automatically apply to everything you have when you pass away. And this plays off of what I was saying, like if there's a friend, a next door neighbor that you name to help you, first off, do not add them as joint owner, like I said, because not only do they jointly own it when you pass away, but they continue to own it. They continue to own it both while you're alive and after you pass away. Extremely briefly is there was a lady who had a very elaborate will, but by the time she died, everything she had was in one checking account, and she had her next door neighbor as joint owner on that account. So by the time she passed away, her will meant nothing because her next door neighbor was joint owner on the checking account, which was all that she had. So that will meant nothing. So if you have a joint owner on something, which is commonly called a joint tenant, that joint owner continues to own it after you pass away. Nobody cares about a will. They just continue to own it. So the second category whenever anybody passes away is if you are the sole owner on something, but you've named a beneficiary directly in a life insurance company system or a bank system, retirement company system, whatever the case might be, that beneficiary gets it when you pass away, or maybe plural beneficiaries. Your will does not apply. So, and then there's trusts. A trust, the biggest pitfall with trust, I literally just dealt with this as a person brought a will or brought a trust to me, and very common problem. They did not have a single thing titled to that trust. A trust does not help you unless you actually retitle things to that trust. There's some things that are good to put into a trust, and there's some things that are not so good to put into a trust. So the fourth and last category are wills or probate, meaning a will, that fourth category only applies to things that those first three categories do not apply to. So I go over all that. It's kind of coming full circle to what I said at the beginning, because probably the most common question I get is, Josh, help me make a will. And this applies whether you're a solo ager or not, frankly, but it's just, my point is your will, there's particularly in 2021, there's people who have nothing that their will applies to when they pass away, but they may have a lot of money, or they may have a lot of assets. So it's not about it's not about how much money you have, not about what you own. It's about how what you have is actually set up or structured. So that's very important. The will doesn't really mean much if it's everything in your life is set up to that your will won't apply to it. So just wanted to come full circle on that. So I think we've got just a couple more minutes if anybody has any last questions, but I'll generally turn it back over to Steve and Carol.
Yeah, no, this is great. I really appreciate everything that you've shared with us, Josh. And let's see, I see that there's S has a question. If the will is filled in advance and filed at the courthouse, is it available to others to view?
Not while you're alive, no. I mean, for example, in Maryland, while you're alive, the will is sealed shut, and the only people who can take it out of the court are either you or an attorney that you authorize in writing. Now, every will, when an estate is opened after a person passes away, then the will becomes open to the public. There's very few wills that are sealed forever. I mean, there's some celebrities. Sometimes a judge will temporarily seal a will, but after you pass away, after your estate is open, it technically becomes public for viewing.
I want to share Burke's first question comment, because I think it's a good one here. And Burke says, as a solo ager with no people whom I want to leave money, but also no one to take care of me, the challenge is how I plan to spend down my wealth. Ideally, I would spend every last penny as I jump in my grave. And she talks about annuities, but that's a real, I'm sure that you have clients that have a similar approach, in that, how do I time my assets to, run out on my last day? Any words of wisdom to folks that are sort of thinking in that direction?
About how to spend their money, that specific part of Burke's comment?
I guess, you see, the problem is, I mean, I've talked to a lot of people that have the same, it's like, I want to die broke, but it's sort of like, since none of us have a crystal ball, you need to sort of utilize what wealth you have and what assets you have effectively to do that. I didn't know if you
Well, I mean, what I'd say is you get a good financial advisor who can help you reasonably invest what you have. I've got clients that want to keep everything they have in a checking account, and that concerns me. I'm not saying they go and invest in fly-by-night companies, but investing in bonds or some very safe investments can help stretch it out. I mean, there is, like you said, Steve, and as Burke said, there is no crystal ball. You can try to die the second your last penny is gone, or to have backup, but it's not going to work. You need to try to. I think Carol's talking.
I think what's really important is that you plan for your long-term care. That's priority. Where do you plan to live when you can't take care of yourself any longer? I wouldn't worry so much about having money left over. What I would worry more about, at least I do, about who's going to take care of me and how will I be provided that care while I'm still alive. And if you have
long-term care insurance can help with that,
And if you don't have long-term care insurance, you need a lot of money in your savings or in some sort of investments to help provide or pay for that care.
Josh, I want to get you to your comments on this question. from Renee. If you've already added your children to a bank account to handle things in an emergency situation, should I try to undo that?
Absolutely. If you've unfortunately added your children as joint owner, yes, you absolutely should undo that. The reality is there's only two ways to do that. Either your children voluntarily sign the bank's form to be taken off as joint owner, or you empty out the entire account and start a new account that just has you as the sole owner.
And
Because
again,
you cannot on your own remove somebody as joint owner once you've added them.
And
So it's very
again,
important that you ask the bank, did I add my child on unfortunately as joint owner, or did I only add my child on as authorized user?
okay,
Most
so
people incorrectly, inadvertently add their children on as joint owner.
so
And
it's
I see
authorized user, not joint owner. That's the
Yes,
clear
correct.
distinction. Okay.
And we have a question about it. Can you just state, I hereby put all of my property in my trust? Absolutely not. That does not work. For example, if you tried to put that in a statement like that in your trust, some random bank will not care about that at all. Because the bank will say, oh, they have their checking account or their investment account or their whatever titled to them still as an individual. So the bank will not care at all about your trust. Or if you own a home and you have not retitled your house to your trust and land records where you live, it's not going to apply to that trust either. If you want your car to be in your trust, you've got to go to your local DMV and retitle your car to your trust. You've got to proactively do these things. The only way that a statement like that even might pass muster, even might some percent chance, are the things in life that have no title. And I'm talking about your couch, your dresser. There's an argument that because there's no central place where that title is, that a blanket statement like that in your trust might work. But for the vast majority of what we have, your cars, your houses, your bank accounts, a statement like that will not work.
And Josh, we could probably do a whole hour on this, but I'd love your comment. Dixie asks, can you speak to the abusive nature of well-resourced folks and adult children who hire an attorney to move money so folks can qualify for Medicaid, a federal safety net for folks who are poor? Can you sort of share?
Yeah, you're right. I could spend a whole hour on that. And unfortunately, I do not have an hour, but I mean, just very, very briefly, there's advanced Medicaid planning. The one big takeaway, good advanced Medicaid planning, you have to do at least 5 years in advance before you even apply for long-term care Medicaid. So in other words, when you apply for Medicaid, the government has the right to look back in the previous 5 years. Did you give anything away for less than fair market value? Did you sign your house away to your daughter or your next door neighbor or whatever? And if you do, then it's what's called a penalty period for which Medicaid will not work. And there's emergency Medicaid planning where some of what you have can be saved, but by no means everything can be saved. It depends on your state. For example, does your IRA count towards your asset limit and so on? It's probably about as good as we can get involved in that today.
Yeah, I mean, my understanding in having this question come up to a lot of the elder law attorneys that we've had is that it's, back in the olden days, there was a lot more of this activity going on, but the restrictions now and the lookbacks are rather extensive. I'm sure things still go on,
yeah,
but
absolutely.
It seems like they've plugged a lot of the holes. I know we're at 1 o'clock. If we can, could you answer Suzanne's question? What about a pour over will to the trust? What is?
Yeah, pour over will is a will that says anything that probate applies to, add that to my trust after I pass away. So for example, very common thing is a car. Most people never retitle their car to their trust, even if they retitle everything else they have to their trust, they do not retitle a car. So what a pour over will says is anything that must go through probate, your local probate court or register of wills, that will get added to your trust through probate. So a pour over will does not automatically add anything to your trust. It just allows it to go into there through the court probate process.
Okay. Well, man, this is has really been a great discussion. And
Yes, it is.
Carol, you're probably the best co-host that I've ever had, because most don't sort of jump in as well as you did. So we got to keep the solo aging conversations going.
Absolutely.
And Josh, you did a great job of bringing up some topics that are very important.
Well, thank you.
Yeah. Thank you, Josh. It was great.
Absolutely. Well, very sorry, but I do need to jump off now. But I thank everybody for listening, and of course, Steve and Carol as well for inviting me.
Excellent. We'll see you guys at the next one, and I'll make sure that everybody's contact information is on the recording. Thanks a lot, Carol.
Right.
Thanks a lot, Josh.
Thank you.
Oh, thank
Bye-bye.
you.